Today I've come to the office of Andrew Isaacs Law in the Pera Business Park here in Melton, and I'm chatting with Bethany Chambers, who is the new paralegal at Andrew Isaacs Law. So thank you for inviting me to your office, Bethany.
That's all right. It's lovely to see you.
And you've recently moved to this area. So Bethany, tell us a little bit about yourself.
So I grew up in Australia and completed my law degree in Queensland, and then in February 2025 I relocated to the UK, and I now live in Wymondham, which is just outside Melton Mowbray, and loving it.
It's a lovely village, Wymondham, a lot going on there.
Absolutely. It's about to be Feast Week as well, which I'm very excited for. There's lots of volunteering there. I absolutely adore my village. It is amazing. Everyone's really friendly and welcoming. And there's just so much going on in my village.
Have you joined any of the groups there?
Yes, so I'm part of the Wymondham Table Tennis Group and the Wymondham Theatre Group, the Stars, as well, which is really exciting and a lot of fun.
And what else do you enjoy doing in your spare time?
So I run. I try and do the Wymondham 6 most days. And I like to ride horses as well, which is wonderful given my village is very horsey, so it's very nice.
So Bethany, at Andrew Isaacs Law, what are your specialisations?
So I specialise in wills, lasting powers of attorney and probate. So I do all the estate management legal side of things for everyday people, families, clients, farmers, people in care as well.
So talking about wills, a lot of people will say, do I really need a will? Can't my family just sort things out?
Yes, I can't stress enough how much a will is needed. A will is perhaps the most important legal document you will ever need. Without a will, if you were to die without a will, the law then decides who inherits your estate under what we call the rules of intestacy. So this won't necessarily follow your wishes, it follows your family's bloodline. So this means if you're unmarried or you have stepchildren, they probably won't inherit under these rules. So a will puts your estate in your control. It puts it in your hands. So you can choose who inherits, you can choose who you might be leaving out, and you can choose how your estate is divided upon death. Without a will, it won't do that. It will just simply follow the rules of intestate, which is just via bloodline, not by your wishes at all.
Now, these days, a lot of people just live together without being married. What's the effect of that on having a will?
So just because you're living with someone doesn't mean they're going to inherit. If you're not married, then they don't have a claim over your estate. So it's really important, if you are living with someone and you're not legally married to them, put a will in place so they can still benefit from your estate, because under the rules of intestacy, they won't.
Can you just write your own will?
Technically, yes, but I wouldn't. Wills can be quite complicated, and specific wording is needed for certain things. By writing your own, you're leaving yourself open to disputes, mistakes being made in wills as well. And if you don't execute a will properly, that means if you don't have it drafted properly and signed and witnessed properly, it can actually be completely invalid, which can cause issues with your family post-death, but also costs a lot of money to get a badly written will fixed when it comes to the probate side of things.
Does marriage affect the will?
Yes. So at the moment, on the current laws, getting married automatically revokes any existing will made in England and Wales. There's ways around this, so you can have a will made in contemplation of a specific marriage, but getting married does revoke any former wills. Many people don't understand this, but another thing is if you were to get divorced, that doesn't necessarily revoke your will. If you were leaving your ex-spouse something in your will and then you got divorced, it's been treated as if your spouse has predeceased you when it comes to administering your estate.
Can someone exclude somebody from their will?
Absolutely. You can do what you want, really, with a will. It's just about making it legally safe to do. So you can exclude anyone you want, The only issue with excluding someone is spouses, children, and people who are financially dependent on you can still make a claim against your estate. That's why it's really important to get a legal professional to draft your will to help minimise that risk and make sure you have got a really watertight will if you are intending to exclude someone that could have a claim on your estate.
What happens to the will once it's been made?
So here at Andrew Isaacs, we store all of the wills of our clients that we've drafted. The reason we do this is because when you apply for a grant of probate, you do require the original hard copy of the will. And these things over time do go missing. So we do, free of charge, hold our wills in safekeeping. You can access it any time you want. When you pass away, your executors can get in touch and we can release the will to you. The reason we keep it is just to keep it safe, because it is significantly more expensive to apply to the probate court if you've got a copy of a will, you've lost a will, and it does change how your estate is handled.
So it all simplifies it if you do everything?
Yeah, I think having all your legal documents in one place when it comes to estate planning is really important, not just for yourself but for your family, so they're not running around trying to find where a will is, who's got the last will. If your family know who you've drafted your will with and who's holding it, then it's a really simple process to go and get your will released.
So, Bethany, your other area of specialisation is lasting power of attorney, and a lot of people won't understand what that means. Would you like to explain what it means?
Yes, so a lasting power of attorney, there's actually two different types. Incredibly important documents to have. I always consider wills to be the documents that work after death, and LPAs are the documents that work during life. Very important distinction. So a lasting power of attorney is called that because it stays in place when you were considered to have lost capacity. So it's a legal document where you appoint someone you trust to make decisions on your behalf. We call these attorneys. There are two different types, a property and financial and a health and welfare one. So the property and financial lasting power of attorney allows people to make decisions on your finances on your behalf and in your best interest. Now, interestingly, this lasting power of attorney you don't have to have lost capacity for it to start working. You can choose for it to start working upon registration, which is a really helpful thing because you could be on holiday and, for example, let's say you've appointed your son as an attorney and you've decided to go on holiday. You are stuck on the Eurostar with no internet and you've got to pay a bill. Even though you're alive and you've got capacity, because you've appointed your son as someone you trust, he can call up the bank as an attorney and say, hey, can I please just make this payment to come through? And he's got the power to do that if you let him. It's completely up to your discretion if you would allow that, but it would work. With health and welfare, that only comes into place when you are considered to have lost capacity. So these are really important life decisions about your care, certain medical treatments you may or may not want. If you're on life-sustaining treatment as well, you can appoint someone to make decisions about that as well. So two separate legal documents, both equally as important, and you need to be able to put them in place before you've lost capacity. I always consider LPAs to be a bit like car insurance. You can't take insurance out after you've had a car accident. You need it beforehand, and that's essentially what an LPA is.
People might be worried about the amount of power that an attorney can have. Can an attorney do whatever they want with my money?
No, they can't. So when you appoint an attorney, they have a duty to make decisions for your best interest. So no matter what they do, they are legally required to act in your best interest, keep records of what they've done, and follow the principles of what we call the Mental Capacity Act. They cannot make gifts beyond what you've already approved, and if they misuse their position, they can actually be criminally liable. So it is their duty for them to act in your best interests as well.
So there used to be a document called an enduring power of attorney. Is that still valid?
They are still valid. Enduring powers of attorney are fairly old documents now. They were made before 2007. But they only work in finance situations, and they don't work when you've lost capacity. So the LPAs, the lasting powers of attorney, have replaced them, and they offer much wider protection, and they also have the health and welfare option now as well. So your enduring power of attorney, if registered and done correctly, is still valid, but I always suggest it's best to redo and have your LPAs done just for that better bit of protection.
So, Bethany, if people would like more details, how can they contact you?
Yeah, brilliant. So they can contact me via our website at andrewisaacs.co.uk, or you can make an appointment to see me via the phone. So my phone number is 01664 896 218, and you're more than welcome to make an appointment and come in and talk about your wills, your lasting powers of attorney, and any probate questions you may have.
Well, thank you very much, Bethany, for telling us all about wills and lasting power of attorney. That's been very interesting.
Thank you so much for having me. I've really enjoyed it.
Thank you.